Right, I want to say a good afternoon to our honorary guest, the Honourable Dr. Jocelynne Scutt AO. Good afternoon, Jocelynne. How are you?
I'm well, thank you, Ian. How are you?
I'm fine, thanks. Really good to speak to you again on the radio.
Yes, good.
And we've just spoke to Chris earlier, Chris Gibson, and I've just got a bit to something to read out before we get into the questions. So, the necessity of a legal challenge on foot is no longer a prerequisite to accepting an invitation to join mediation or to initiate it. The former Secretary of State for Work and Pensions unlawful refusals, as found by the Cedar-in-Law's legal team, to join reasonable invitations to mediation placed the current incumbent Minister Liz Kendall in jeopardy of a clear case being found against her unless she accepts mediation. So, what legal obligations must the Secretary of State for Work and Pensions meet out of the judge's report and the new historic civil procedure rules on alternative dispute resolution, or as we call it, mediation?
Well, Ian, just on the latter aspect, it's really clear that there is no need for legal action to be initiated in a court of law for the government, for example, or any party, but in this case the government, to enter into mediation where there is a dispute. Now, number one, there can be no doubt that there is a dispute in relation to the 1950s women and the change of the pension age from 60 to 65 and the way that that was administratively affected, because the government itself effectively acknowledges that there is a dispute because they've acknowledged that in Parliament in their response to the Ombudsman report. They've acknowledged it, various members have, by meeting together with another group in relation to this issue, and also by communicating with Cedar-in-Law. They have acknowledged that there is a dispute. So that's number one. Number two, the government enters into mediation on this matter where there is uncontrovertibly a dispute, then what it is doing is sensible because it is avoiding the cost of legal action. And that's costs on the part of the government and it's costs on the part of, for example, Cedar-in-Law if they have to initiate legal action. So it's not really sensible, in my view, of the government to say we're not going to enter into any mediation. Any organisation, in my respective view, that's in a dispute or that is a party where there is a dispute ongoing, who refuses to enter into negotiation, mediation, is, with respect, not acting sensibly. And they are putting themselves in jeopardy where if eventually legal action were initiated and in the papers it was made clear that mediation was proposed before legal action was initiated, that would be grounds for granting costs against the government. So that's the issue in terms of mediation and no need for a legal action to be initiated. The second point is that focus seems to be at the moment on the Ombudsman report, which looked explicitly and only at the limited question of whether the 1950s women were notified or not of this change to the pension age. And the Ombudsman report is, of course, extraordinarily limited because it addresses only that question of delay or non-notification, delay in or non-notification of notice to the 1950s women. Now, one's not blaming the Ombudsman because their, as they say, their remit is in accordance with the terms of whatever it is that governs the Ombudsman, that is, the law that governs the Ombudsman. But to ignore the discrimination element is really to ignore a significant part of what's in issue here. And so I just end this part of my response to you, Ian, by saying that, number one, in any event, all that the Ombudsman looked at in the end was six individual women who were born in the 1950s, and whether or not they'd been notified, if they were notified, when they were notified, and whatever the delay was. Now, to put the whole issue of 3.8 million women on the basis of six individuals does not, with respect, sound sensible. In fact, it seems that most unwise, and that there's a certain element of unwisdom in this whole issue and the way that it's being addressed by government. All that we can trust is that within the government there is sense, and that eventually what will be recognised is that the 3.8 million, rather, need to be regarded with respect, and what has happened to them needs to be addressed.
Yes. I wanted to move on to, does Sir John Hayes' hardship fund for some WASPy women meet these legal obligations?
Well, thank you to Sir John Hayes for putting forward his proposal. It's important that there is someone at least putting forward a proposal and not saying, no, nothing will be done. However, the issue of hardship, and to address the matter in this way, it has its flaws. Because first of all the 1950s women, apart from a very few who will say, well, look, it hasn't affected me at all, I've got an income and I've got a private pension and so forth. Well, we're very pleased that some women are in that fortunate position, but it's not very many. And the vast bulk of this 3.8 million women are in difficulty vis-a-vis the pension in itself and the age change. So if we look at hardship, then number one, we say, well, who isn't in hardship? But number two, how is this to be determined? And what it's doing is placing the obligation in the wrong direction, because when we come to hardship, it's going to be to each of these women, 3.8 million of them, less those who say, well, I'm not impacted by all this, thank you, and I haven't got a problem. So they're all going to have to produce to the Department of Work and Pensions the basis on which they say they're in hardship. Now, if we just actually ignore for one moment the burden that this puts on the women, and it's the burden in the wrong direction, let's think about the burden that it puts on the Department of Work and Pensions. Because not a week goes by, or a month perhaps, if we look at it from that perspective, when a report comes out in the news media that the Department of Works and Pensions has not paid some sum to some group that are covered by some element of pension, and that they have to readjust all their figures and pay out something to this group. And it's numerous groups that this has happened to. As I say, I would be wrong if I said that there haven't been problems in the Department of Work and Pensions in terms of calculation in relation to other groups. So do we really realistically, or does the government realistically, or does Sir John, for that matter, want to put another burden on the officers of the Department of Works and Pensions? I have to say, I have, as well as having considerable sympathy for the 1950s women, the 3.8 million of them, minus the very few who say it doesn't matter to them, I have great sympathy for them. But you see, I also have great sympathy, I'm afraid, for the workers in the Department of Work and Pensions. Because do we want to put another burden on them when they already run the problem of media reports about how the department is in disarray? I don't think that's a wise route to go. So it's unwise from the point of view of the department itself, putting this burden on the department, And with respect, it's not wise in terms of the women themselves, because they're going to have to get together their material, go to the department, get on a queue for their matter to be email computer system, sending in emails with all their evidence. It's a burden on the Department of Work Pensions that they ought not to have to bear, and it's a burden upon each and every one of the 3.8 million women, bar the ones who say they don't care, it doesn't impact on them, etc., etc. And so are they going to be queuing up at the door of the Department of Work and Pensions? Are they going to be on their computer, sending in an email with a lot of attachments and so forth? I don't think this is wise. And thank you very much to Sir John for endeavouring to resolve this matter. But I'm sure that when he reflects upon it, he will realise too.
Yeah, it sort of sounds like something that you've got to claim for, where, again, something that you're actually entitled to.
Well, exactly. And as you read out in that very perceptive communication from one of the 1950s women,
post the government's rejections of a claim based solely on maladministration for some waspy women, does CEDAW in law's claim on behalf of all 1950s women remain in play?
Well, this is a very interesting question, because you see, when you look at delay and you look at the Ombudsman report, the Ombudsman report was about six women. It was based on evidence relating to 6 women. And so therefore one could argue, surely, that the government's rejection of the Ombudsman report is a rejection of 6 out of the 308 million women who were impacted. And so therefore one can say, well, what about these other 3.8 million, minus the ones who say they don't care, and minus the 6 who were the Ombudsman report subject? And insofar as failure to notify is, first of all, what the Ombudsman report has come up with is failure to notify those 6 women. So and they've limited, the Ombudsman report limits that to a very short period of failure to notify, whereas there's evidence that whatever happened to those 6 women, there are other women who were not notified at all, and who were notified the day before they turned 60, the month before they turned 60. There's evidence to the CEDAW in Law Pensions Tribunal and or the CEDAW People's Tribunal on the need to domesticate women. Even if one were to concede that delay has been addressed by the government and they said nothing doing, actually doesn't address the other issues, their obligations under CEDAW and their obligations under the European Convention, and it doesn't cover also the legal rights under CEDAW, which was ratified by the United Kingdom in 1986. Even if one says that the whole delay question has been wrapped up by, and they've said no, I mean, I'm not conceding that, and I don't think CEDAW law is going to say that.
I wanted to go on to the 4th question, and then we'll come back to the 3rd one, I think. Can you tell our listeners about the new historic CEDAW Treaty, General Recommendation 40?
Yes, General Recommendation 40 was agreed to and promulgated by the CEDAW Committee in Geneva last year, that is in 2024. And I actually went to Geneva in relation to that general recommendation to present a submission to them. And what General Recommendation 40 says is that in any matter the government addresses, a government that's committed itself to and ratified CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, any government in that setting must, when an issue arises that relates to women, engage women equally in discussion and resolution of the issue. So that if we come to this issue of 1950s women, it's no good for the government to simply say, we're just addressing this and we're talking about it to each other. They have to consult with the women involved. They have to consult with representatives of the women involved, because what the CEDAW General Recommendation 40 says is that women's voices must be heard. And when you think about it, every issue in government is relevant to women, and therefore women's voices must be heard and listened to by government in relation to every issue with which it deals, and most particularly in this context with the 3.8 million women's issue relating to the change in the pension age. Yeah.
Now, we'll go back to question 3 again. So this was the government's rejections of a claim based solely on maladministration for some WASPy women. Does CEDAW in law's claim on behalf of all 50s women remain in play?
Well, interestingly, the Ombudsman report in the end relates to 6 women only. So therefore, when the government says, well, we're not doing anything about this because of the Ombudsman report, they're really saying that they're not going to do anything about it in relation to the 6 women whose position was addressed by the Ombudsman. So therefore, the whole other 3.8 million women, minus 6 women in the Ombudsman report, and minus those women who say we don't care because we're all right, although that 3.8 million women, they're still outstanding, aren't they? But even if one were to concede, which one doesn't, that the delay issue has been addressed, that does not address the other issues, the government obligations in relation to CEDAW, which it ratified in 1986, and which it's obliged to follow under international law because it ratified that convention or treaty, and also the European Convention on Civil and Political Rights. That governs the government as well. And if, as it has, the Department of Work and Pensions has undertaken administrative action in relation to the 1950s women, well, then that would be susceptible to the operation of the Equality Act of 2010. And the issues under CEDAW and the ECHR are that discrimination has happened here, direct discrimination in relation to age and in relation to sex, and indirect potentially in relation to marital status. The latter, because there are women who gave evidence to the CEDAW tribunals, CEDAW and CEDAW in law tribunals, that when they went through divorce proceedings, the divorce proceedings continued and were settled on the basis that they were getting the pension at 60, which was incorrect. So that therefore this impact is differential against the women who were in that position. Insofar as direct discrimination, that is less favourable treatment, the women were less favourably treated by this change because they had to renegotiate their retirement plans. They had to scrabble about begging their employers to keep them on, and where the employer wouldn't keep them on, they had to scrabble about to try to find a job. Now, anybody who knows anything about the world and who is fair will acknowledge that a woman of 60 endeavouring to get a job or to hang on to the job she's got is not an easy thing to do. Indeed, it's extremely difficult. And therefore, but there was no man in that position because men were receiving the pension at 65 and then it went up to 66, that's true for everyone. But nothing impacted on the men of 65 because they didn't have to change their retirement plans under the 1995 Act because it related only to 1950s women. Of course, it impacted later on women born in the 1960s, but the 1950s women were the transition group. And in relation to age, it specifically targeted women born in the 1950s. Didn't target women born in the 40s, no, they were left out, and it didn't target 1960s born women. The 50s one purely because of their age and their date of birth, that was the group that had to wear the transition from 60 to 65. And then it's also less favourable treatment within that group as well on the basis of age, because some women got it, say, 3 months after their birthday. Some women got it on their birthday, but a year or 2 years or something after their birthday of 60. And other women got it not on their birthday and 2, 3, 6 years after they should have got it. And therefore, that's age discrimination. It's less favourable treatment within that group of 1950s women, and it's less favourable treatment on the ground of age in terms of 1950s women and all the other women, and indeed the men on the basis of sex, because the men were not impacted when the age of women went up to 65. They still were in the same position, unless, of course, they had a wife who was impacted, and some of those men will say very sympathetically to their wives that it did impact on them because they were in a position where the expectation of that family was that the woman would retire at 60 and the man would retire at 65.
Yes, that's right. And what I want to say, Jocelynne, because I'm going to play a track. This is a Beatles track, but I just wanted to say we've got a call to action. So I want to invite listeners to contact their MPs and ask them to get behind mediation on behalf of all 1950s women. And you can do that. You can find who your MP is if you don't know who your MP is at https://members.parliament.uk/find your MP. So I invite people to contact their MP and get behind mediation for all 1950s women. So, Jocelynne, thank you very much. We got there in the end, didn't we, with the phone line? So it's been lovely to speak to you again. And I wonder if you'd like to introduce your track by the Beatles.
Yes, well, it's wonderful. The Beatles, of course, are very important. They made such a difference to the whole 1960s, 1970s experience for young people, for older people, and for people who are older now and who grew up during that period of the Beatles. And so I'd like to introduce this track from the Beatles, which is an important track to end the discussion about this most important issue, about the 3.8 million women, minus those who say they don't care, who have been brutally impacted by the change of the pension retirement age for women from 60 to 65 and then to 66.
Thank you, Jocelynne. Lovely to speak to you again.
Thank you, Ian.